Welcome to episode 84 on the law report. In this episode, I'm going to deal with hearsay evidence in criminal proceedings. But before I do, my usual disclaimer: this is not legal advice, should not be construed as legal advice, and for legal advice, please contact an attorney of your choice. Welcome back. Today's episode is confined only to hearsay evidence in criminal proceedings. So we'll start with the obvious. What is hearsay? What is hearsay? The law relating to hearsay evidence in criminal proceedings may appear to be rather complex to the layperson, but to a seasoned legal practitioner, it may be quite straightforward. Hearsay evidence is essentially any oral or written statements made by a person who is not testifying in court, but those statements are relied upon to prove that which is contained in them. In other words, they are being presented to prove the truth of what is stated. The classic definition of hearsay at common law was formulated by Sir Rupert Cross and subsequently endorsed by the House of Lords in the case of Regina and Sharp, where it was held that an assertion other than one made by a person while testifying in proceedings is generally inadmissible as evidence of any fact asserted. So it was held that hearsay evidence is inadmissible as evidence of any fact asserted. For example, a witness in a trial for a matter of wounding may testify that he heard someone said that she or he saw the accused stab the alleged victim. That statement is hearsay if it is being put forward as a fact, because it was put forward by someone who may not have seen the incident but only heard about it. Therefore, it cannot be relied upon to prove that the accused indeed did stab the alleged victim. Therefore, the general rule is that hearsay evidence is not admissible in criminal trials. However, there are limited circumstances in which hearsay evidence may be admissible. And there are 4 situations in which hearsay evidence could become admissible. 1, where all the parties in the proceedings, that is the prosecution, the defense, and even with the agreement of the trial judge, agree to the hearsay evidence being admitted. 2, where admitting the hearsay evidence is in the best interest of justice. For example, a witness may have heard a person said that the offense for which the accused is being charged was not committed by the accused because another person was seen committing the offence. The judge in that case may decide to admit the evidence in the interest of justice. The third exception to the admissibility of hearsay or to the inadmissibility of hearsay evidence is where there is a common law exception, and there are several common law exceptions which I will deal with further in the episode. And fourth, where there is a statutory provision making the hearsay statement admissible. And in that context, I will deal with the situation of the statutory exception in the Turks and Caicos Islands and in England and Wales. Please note that the Turks and Caicos Islands is still predominantly a common law jurisdiction, and so the common law principles governing the hearsay rule is the guiding principles that govern hearsay in the Turks and Caicos Islands, except where statute makes an exception for the admissibility of hearsay evidence. So, for example, in England and Wales, the statutory exception can be found in the Criminal Justice Act of 2003. And in that act, the essence of hearsay is that it is a second-hand account of a relevant matter. And it comprises of 4 elements. 1, that there must be a statement, that statement must be made out of court, that statement must be relied on for the truth of the matter stated. And 4, the purpose of the maker of the statement is to cause another to believe or act on the fact stated. That is the definition of hearsay evidence as found in the Criminal Justice Act 2003 in England. That act does not apply to the Turks and Caicos Islands. However, in the Turks and Caicos Islands, the Evidence Special Provisions Ordinance provides a statutory exception for hearsay evidence to be admissible. For instance, Section 8 of the ordinance deals with first-hand hearsay and its admissibility. Section 9 of the ordinance deals with business documents and their admissibility. Section 10 of the ordinance sets out the principles to be followed by the court before such evidence can be admitted. It provides a guidance and a threshold that must be met and the considerations to be taken by the judge before the hearsay evidence is admitted. Section 11 deals with evidence from computer records and set out the burden of proof and the party relying on such evidence. And Section 12 of the ordinance deals with statements in documents which appear to have been prepared for the purpose of criminal investigation. And in this instance, the leave of the court is required before the evidence could be admitted. So let's bear in mind, if a party to a criminal proceedings is not relying on an out-of-court statement for the fact stated in the statement, it is not hearsay. So what are the common law exceptions? 1, evidence of a person's repetition is admissible for the purpose of proving his good or bad character. So character evidence is an exception to the hearsay rule. Confessions are also an exception to the hearsay rule. A statement containing a confession is admissible against the maker of the said statement. So if someone during an investigation where the formalities of the judge's rules, and I dealt with the judge's rules in an earlier episode, but if the formalities of the judge's rules haven't been complied with, and that person made a confession admitting that he or she committed the offense in which he or she has been investigated for, then that admission or that confession is admissible and falls within the exception to the hearsay rule. Another common law exception is admissions by agents. So the common law rule whereby admission made by an agent or a person appointed by a defendant to answer questions on behalf of the defendants are admissible in evidence against the defendants. Another exception has to do with common or joint enterprise or joint ventures crimes. For example, if A, or defendant number one, in the course of committing a crime, makes a statement that B, or defendant number two, was also involved in committing the same crime, the common law allows this statement to be admitted at trial as proof of the fact that defendant number two, or B, committed the crime. In order for such statement to be admissible, however, it must be proved that there was a common joint criminal enterprise or purpose, and the statement was made to further that purpose. Another common law exception is what we call expert evidence, where someone duly qualified in the field is deemed to be an expert and is allowed to give evidence about a particular subject matter. In that case, that expert is entitled to rely on the findings of other experts in their field of expertise, which would otherwise have been considered to be hearsay evidence. Another common law exception is that of res gestae, and this refers to an event at issue and things said or done contemporaneously or spontaneously, typically in close proximity to that event. In relation to evidentiary matters, something said res gestae is often considered to be a spontaneous response and generally considered to be credible piece of evidence. An example would be a statement of a person who witnessed a crime and who was so emotionally overwhelmed by that event that there is no possible way for that person to distort or concoct whatever was said. This exception is also preserved by the Criminal Justice Act of 2003 in England and Wales. So that is hearsay evidence and its admissibility in criminal proceedings in a nutshell. I will just look briefly at hearsay in the United States, because the United States is also really a common law jurisdiction, and I will look at hearsay evidence at a federal level. So in the United States, the hearsay rule is a rule prohibiting hearsay or out-of-court statement to be offered as proof of that statement from being admitted as evidence because of the inability of the other party to cross-examine the maker of the statement. So the principle is basically the same as it is in the English jurisdiction, England and Wales and other common law jurisdiction, Turks and Caicos Islands and Caribbean. Africa, Singapore, and other countries that follow the English legal principle, Taiwan, Hong Kong, etc. There are a number of exceptions to the hearsay rule, and this is continuing with the position federally in the United States. Some of these exceptions include present sense impression, excited utterances, declarations of present state of mind, dying and business records exceptions, as well as things defined not to be hearsay, for example, admission of a party, opponent, and prior statements of a witness. So for federal trials, rules for hearsay are contained within Article 8 of the Federal Rules of Evidence, Rules 801 to Rule 807. So there you have it, folks. Hearsay evidence in criminal proceedings in a nutshell. Here is where I'm going to leave it for today. If you like this episode, please give it a thumbs up. But most of all, I thank you for taking the time out to listen to this video. Cheers, and I will see you very shortly in my next episode.